Of the presidential directives, and I've simplified the 23 down to the points for lawyers that will make practice differences or you will see or interact with. A very significant and intense focus by ATF and by state and federal law enforcement and by various groups around the country focuses on the occasional buyer and seller. And because I represent individuals from manufacturers to gun shows to individuals, I get this question a lot: how can someone lawfully transfer a firearm from one person to the other without doing a background check, which is generated by virtue of doing the federal form in a new purchase, which is the 4473 form, 4473. If you're new in this arena, it used to be called the yellow form. Now it's digital, and I don't think it's yellow anymore. It's just white paper. But the 4473 form generates a NICS background check. That's done for new purchases, and in some states is required, or some kind of background check to transfer once it's purchased at retail to a second and subsequent owner. It's not always required. In fact, under Chapter 44 of the Federal Code, it embodies, and it embodies it also in other places in that same code provision, as well as the federal regulatory sites, the fact that individuals in the American system buy and sell as a hobby, or buy and sell to liquidate a collection or build a collection. They are exempted from the requirement of having a federal firearms license to sell firearms. If the notion is we're buying it to build a collection, to liquidate a collection as a hobby, the objective has to be the principle of livelihood or gain to need of FFL. In the President's most recent directive, it indicates as few as 2 firearms being sold without an FFL to another individual can be a violation. Historically, that's not been ATF's position. It's been a few hundred, but it's repetitive sales. It's sales of the same gun multiple times. That is absolutely prohibited under federal law, and anyone that's going to be buying and selling, even the liquidated collection, needs to be very cognizant of the actual or perceived perception of law enforcement is that exception to having a license and to doing a background check is being exploited, and they're intensely looking at those transactions through a variety of techniques, and I won't go into what those are. If you're a criminal defense attorney, you'll know, but I'll give you a general example. One's a controlled buy, and that's done with drug deals, guns, or other contraband, where it's audio and videotaped, someone trying to present an order for cocaine, or hey, I want to get this gun, do you have it? Well, if you're an individual that's building a collection, liquidating a collection, or for a hobby, you're not going to say, you know what, I don't have that, but I'll be getting one in stock. If that's the language your client's using, or that's the language that's being heard and recorded, that means that person is selling firearms without a license, is in direct violation of federal penal law, and those are getting prosecuted in federal court, or state law. But that's where the ability comes about to buy and sell a firearm without doing a background check. Whether those guns wind up in the streets and in gun crime, I don't know. Whether those guns are the problem for gun crimes, I don't know. I will say the low price point guns are singled out significantly to be used in crimes more often and purchased lawfully the first time around. Are they stolen from homes? Those are all questions we need to wrestle with, but as far as buying and selling in this loophole that's called the gun show loophole or called a variety of other things, there isn't a loophole. It's an absolute right guaranteed to every person that is lawfully complying with the U.S. Code, and I would encourage you to look at that and think about what the limitations and exceptions are. Increased mental health reporting is something I've talked about since I started in this topic of where a root cause is, and we're not going to solve that problem in this webinar today, and if I could solve it, I probably would not be here. I'd be doing something grander, and hopefully you would as well. Notwithstanding, that is a thorny issue no one knows how to handle, and here's why. For years, we've chronically underfunded mental health in the U.S. because it's something you can't put a diagnosis code on as well as a broken leg or a broken arm or a surgery, or or give a prescription medication to, it's very difficult to A, diagnose, and B, figure out what a treatment plan is, and here's the comma, if any. So we're focusing on mental health treatment and reporting. I will tell you that doctors and states have had some pushback across the country. Doctors are afraid if they report their patient that they'll wind up getting sued by the patient, and states that are, I'll use the term pro-gun states, have actually tried to adopt legislation prohibiting doctors from sharing certain information with the NICS system or the federal government as a whole as it relates to this directive. And I have no position on that except to say there are a lot of legal loose ends to this issue that are going to have to be really thought through in order to have a significant impact on gun crime caused by those with mental health issues. And we talked about earlier some of the mass shootings and mental health diagnoses that existed. The other question becomes, where's the line? And that may not seem like that hard of an issue. If you're mentally ill, you shouldn't own a firearm. What's the definition of mental illness? And I'm, again, throwing this out to stimulate your thinking, depending on where you fall in the spectrum as lawyers and your clients. But using the National Institute for Health, they report 1 in 5 ratio of U.S. adults as a serious mental issue. And I'm probably not using their acronym correctly, but I'll direct you to the NIH site. And 1 in 25 of the adult population suffers from a diagnosable mental illness at any one time. So that is a staggering number of people that would be screened out by a blanket mental health prohibition, and probably still not catch people that don't have an exact mental health diagnosis, or who are, those of you who are more into this particular issue, have dual diagnoses with mental health, like alcoholism masking depression or alcoholism masking something else. Those are the hardest individuals to identify and accurately diagnose, as my understanding from a physician standpoint. They're also the ones that would be hardest to screen in or screen out by more focus on mental health, which brings to light the other two issues. What do you do with the police officers and military who are clinically depressed or having some episodic event of a psychological diagnosis? Are they prohibited, and how, once you prohibit someone, do you get them off the prohibited list? You can't take an X-ray and quantify that person no longer has a schizophrenia diagnosis or a diagnosis of bipolar disorder, or something under those umbrella terms that are out there in the psychological and psychiatric arena. The only effective way the military is able to address it, we've all heard about the PTSD epidemic that's raging the country, is for actually deployed troops, they can use waivers because you're not talking about U.S. soil. But this issue is in its infancy. If we're really going to have a rational discussion legally and otherwise as a society about gun crime and hitting root causes, this is going to create an enormous amount of workspace and time for lawyers in fleshing out some of these questions that I'm throwing out for you today. One remedy that's unique in some states is a civil remedy that will allow law enforcement or some doctors to notify law enforcement to confiscate firearms from individuals they believe are mentally ill. And I'm going to use that term in quotes because I don't claim to be a doctor or want to be a doctor or a psychologist, but I know the statute exists on the books, and the police officers and the lawyers and the medical professionals have to enforce it. Is dangerous person statutes, allowing someone the first time around to have their weapons confiscated by law enforcement, and every few months they can go and, if they choose to dispute it, the first time the burden's on the state, the second time it's on them if they are found to be a dangerous person, that the state can retain their weapons. Now there are all kinds of corollary issues like what's it taking if you're faced with that situation, your client doesn't want the firearms back. A tool that I've advised other lawyers to use that's relatively successful is if those weapons or firearms specifically are placed in a property room, it's possible to have an FFL license holder receive a court order from a court to release them to someone with a federal firearms license. Again, there's no book for this. There's no general guidance. It's something that's been successful. The court's going to know that if those firearms by this dangerous person, it's not taking them, and it's going to know that the firearms are put back in commerce in a lawful way and logged in, and the person buying them used or buying them from a retailer who must perform some sort of background check as a condition of having a federal firearms license. So that's a potential tool you can consider in your toolbox of dealing with the complicated and convoluted issues you may face in the gun law arena.